At one time, it wasn't clear whether antitrust laws applied to the healthcare industry. Today, antitrust laws play a significant role in how healthcare entities are structured. The Sherman Act, the Clayton Act, and the Federal Trade Commission Act are key federal antitrust laws that impact the healthcare industry. The U.S. Department of Justice and the Federal Trade Commission enforce these laws. States also have and enforce their own antitrust laws. There's a common saying that antitrust laws are used to protect competition, not competitors. As we go over the key federal antitrust laws, note how they focus on harm to a market rather than harm to specific competitors. Let's start with the Sherman Act. Section 1 of the Federal Sherman Act prohibits agreements among two or more legally separate actors that restrain trade. Although the Sherman Act technically prohibits all agreements that restrain trade, some trade restraint agreements actually increase competition. Thus, Section 1 is interpreted as prohibiting only agreements that unreasonably restrain trade, which generally means they decrease competition. Some agreement types are so likely to be unreasonable that they are per se or automatic violations of Section 1. For example, most price-fixing agreements are per se illegal. An agreement among multiple independent chiropractors in an area to charge a minimum amount for manual adjustments would be a per se violation of Section 1. If an agreement isn't per se illegal, a rule of reason analysis is used to determine whether the agreement unreasonably restrains trade. A rule of reason analysis weighs the agreement's anti-competitive effects against its pro-competitive effects. For instance, suppose a chiropractor sold her practice. As part of the sale, the selling chiropractor agreed not to compete in that area for 3 years. That agreement wasn't per se illegal, but it could unreasonably restrain trade by preventing competition.